Next page. Study Notes, Chapter 10, The Election of the Trustee. 10.1 Election and Appointment. 10.1.1 Election. Creditors who have proved claims may elect one or two trustees at the first creditors' meeting, S54-1, if multiple nominees exist. The person with a majority in both number and value is elected as the sole trustee, S54-2. If one nominee has a majority in value and another in number, both are elected, S54-3b. If one declines, the other becomes the sole trustee. If one nominee holds a majority in either number or value, they become the sole trustee, S54-3a. Election at a meeting not presided over by the master is invalid until confirmed by the master, S56-1. 10.2 Appointment. Only the master can appoint a trustee of a sequestrated estate. Courts lack the authority to appoint trustees, ex parte the Master of the High Court South Africa, North Gauteng, 2011, 5, SA 311, GNP, 327. A judge's appointment is a nullity, Master of the High Court NGP v Mutala 2012, 3, SA 325, SCA. The master must confirm the election and issue a certificate of appointment once security is provided, S56-2. The trustee must publish a notice of appointment in the Gazette, S56-3. The master may appoint a co-trustee if deemed necessary, subject to ministerial policy, S57-5, 6. 10.1.3 Refusal to appoint. The master may refuse to confirm the election of a trustee if improper election, disqualified under S55, failure to provide security, the master deems them unsuitable, S57-1. If the election was unlawful, the master must refuse confirmation and convene a new creditors' meeting, Sabimedi Centrum, EMS, BPK v. Die Meester en Ander 1977, 4, SA 389, t. Suitability considerations, personality, experience, age, diligence, estate complexity, Meskin v. The Master and Another 1963, 3, SA 229, d. The trustee must act independently and fairly, Standard Bank of South Africa v. The Master of the High Court, and Others 2010, 4, SA 405, SCA, 407. The master may blacklist individuals from being appointed, Lipschutz v. Watrous No 1980, 1, SA 662, t. 672. If a trustee's election is declined, the master must provide written reasons, S57-1. Convene a new creditors' meeting to elect another trustee, S57-2. 10.1.4 Objection to appointment or refusal. Aggrieved persons may request the master's reasons within 7 days, S57-7. The master must submit reasons and relevant documents to the minister within 7 days, S57-8. The minister's decision is final, S57-9, 10. This does not exclude court applications to disqualify a trustee, S59, Jordan v. Richter N.N. Ander 1979, 3, SA 1213, O10.1.5 Joint trustees. Joint trustees must act collectively and are jointly and severally liable, S56-4, Goldseller v. Hill 1908 TS, 822-827. If one acts unlawfully without the other's consent, the latter is not liable, Durant v. Fedger General Insurance Limited 2005, 3, SA 350, SCA. If trustees disagree, the matter must be referred to the master, S56-5. Joint trustees may delegate administrative tasks, but not discretionary duties, Miller and Others v. Nufcock Investment Holding Company Limited, and Others 2010, 6, SA 390, SCA, 398. 10.2 Persons disqualified from being trustee. 10.2.1 Absolute disqualification, cannot be trustees in any estate, S55, insolvents. Minors or legally incapacitated persons, non-residents of the Republic, Companies, close corporations or corporate bodies. Former trustees disqualified under S72. Persons declared incapacitated by court under S59. Individuals removed from office for misconduct. Persons convicted of theft, fraud, forgery, uttering, or perjury with a sentence exceeding R2, 000 or imprisonment. Individuals who agreed with a debtor/creditor to grant unlawful benefits. Individuals who induced votes for their election through misrepresentation or rewards. 10. 2. Relative disqualification, disqualified only in specific estates, S55, persons related to the insolvent within the third degree. Persons with conflicting interests against creditors. Individuals who served as the insolvent's bookkeeper, accountant, or auditor in the 12 months before sequestration. Agents authorized to vote on behalf of a creditor. These study notes provide a structured and detailed summary of Chapter 10 while highlighting key legal provisions and relevant case law. Let me know if you need further elaboration. Next page. Summary of trustee vacation, removal, and remuneration. 10.3 Vacation of, or removal from, office. 10. 3.1 Vacation of office. A trustee must vacate office if his estate is sequestrated. An order is issued for his detention under the Mental Health Care Act 71 of 2002, or he is declared incapable of managing his own affairs. He is convicted of an offense and sentenced to imprisonment without the option of a fine. He is convicted of theft, fraud, forgery, uttering a forged document, or perjury, S58. 10. 3.2 Removal from office by the master. The master may remove a trustee if he was not qualified for appointment, his appointment was illegal, or he became disqualified. He failed to perform his duties satisfactorily or comply with the lawful demand of the master. He is mentally or physically incapable of performing his duties. A majority of creditors request his removal in writing. The master deems him unsuitable for the estate. S60. 10. 3.3 Disqualification or removal from office by court. The court may, on the application of an interested party, declare a trustee disqualified from office, incapable of holding office for life or a period determined by the court. Grounds for disqualification/removal: accepting a benefit from a person performing estate work, attempting to influence votes by wrongfully omitting/inserting a creditor's name in records, offering consideration to obtain votes, agreeing to abstain from investigating prior transactions, splitting claims to increase votes, S59. Misconduct as a trustee, Fayno and Whiteford No v. Serpentine 1993, 2, SA 605, A 10.4 Resignation and leave of absence. The master may allow resignation under conditions he deems fit. Trustees must obtain permission for absences exceeding 60 days, S61. 10.5 Election of new trustee. If a sole or joint trustee vacates office, resigns, dies, or is removed, the master must convene a creditor meeting to elect a new trustee, S62(1). 3. The master may appoint a provisional trustee to preserve the estate while the position is vacant, S62(2). 10.6 Recognition of foreign trustee. Trustees dealing with foreign assets must comply with that country's legal recognition process. Foreign trustees must obtain recognition in South Africa before dealing with local assets. Further details in Chapter 29. 10.7 Remuneration. 10.7.1 Entitlement to remuneration. Trustees are entitled to reasonable remuneration, taxed by the master according to Tariff B in the second schedule to the Act, S63(1). No remuneration is payable until the estate account is confirmed. Avi MacLeod 1935 EDL 284, Stridham No v. Master of the High Court 2010, 6, SA 630, GNP 636. The appropriate stage for remuneration increases is when the liquidation and distribution account is submitted. Bester No v. Master of the High Court, ECP 2013, JDR 0880, ECP Tariff B entitles the trustee to 10% of the gross proceeds from movables, promissory notes, book debts, rent, interest, or other income. 10.7. To master's power to adjust remuneration. The master may reduce, increase, or disallow remuneration for good cause, S63(1). Good cause includes factors such as complexity of the estate, degree of difficulty in administration, amount of work done and time spent, difficulties encountered in asset management, Nel No v. The Master 2005, 1, SA 276, SCA. The master must decrease excessive remuneration if the work done does not justify it. 10.7.3 Judicial review of master's decision. The trustee or an interested person may take the master's decision on review, S151. The court will not interfere unless there is bad faith, mala fides, or illegality. Cooper v. The Master 1996, 1, SA 962, N. 10.7.4 Reduction of remuneration. The master may reduce remuneration for unsatisfactory performance, Thorn v. The Master 1964, 3 SA 38, N. Misconduct, Standard Bank v. The Master 2010, 4 SA 405, SCA 435. If there are joint trustees, remuneration is equally divided, unless agreed otherwise. Cooper v. Master of the Supreme Court 1998, 1, or SA 158, N. Bota v. Swanepoel 2002, 4, SA 577, T. 10.7.5 Prohibition on additional payments. A trustee cannot receive additional remuneration outside what is prescribed in the Act, S63(2). Prohibited payments include auctioneer's commission, fees for services as an attorney/conveyancer, payments to partners, employers, or employees for estate services. George Hartman and Key v. Landros, Rights 1958, 4, SA 514, 010.7.6 Costs of remuneration. Trustee remuneration is paid as a cost of sequestration, SS 89(1) and 97(2)(c). Next page. Chapter 11, The Duties and Powers of the Trustee. 11.1 Taking charge of assets and documents. The trustee must collect and preserve estate assets for the benefit of creditors. Duties and powers imposed by the Act, with additional procedures discussed in later chapters. Impeachable dispositions, Chapter 12, Interrogation of the insolvent and witnesses, Chapter 13, Obligations of the insolvent to assist trustee, Chapter 14, Independence and impartiality. The trustee must remain neutral and protect all creditors' interests equally. Goldseller v. Hill 1908 TS 822. The trustee is not in breach of trust if they act in the creditor's best interests. Hobson No v. Abib 1981, 1, SA 556, N. 560. Failure to perform duties. The master or interested party may apply to court for an order directing the trustee to fulfill duties, S 116 bis 1. If improper conduct is found, the trustee may have to pay costs personally. Cooper No v. First National Bank of SA Limited 2001, 3, SA 705, SCA 717. 11.2 Collection and control of assets. Movable property. Trustee takes possession after the sheriff's inventory under S19. Valuation of movable assets required by an appraiser approved by the master, S69(1). A secured creditor may retain and administer movable property, S83. Search and seizure. Warrant for concealed property. Magistrate may issue a search warrant for suspected concealed/withheld estate assets, S69(3). Must be executed properly by authorized officers, Libir No and others v. Magistrate of Dundee No and others, 2021, 1 All SA 405, KZP. Does not remove the High Court's power to issue a warrant. Insolvency No and another v. Alba Scrinworkers Chibu Proprietary Limited, 2022, Zanch 38. Execution of warrants. Property must be delivered to the trustee, S69-4. Criminal law procedures do not apply, Naidu and others v. Kalyan G. No, and others 2016, 2, SA 451, SCA. The magistrate must verify facts before issuing a warrant, Bruel Constructie, Edens, BPK v. Whitson No 1980, 4, SA 703, T. 711. Standard of suspicion. Trustee does not need prima facie proof but must show reasonable suspicion. Philip Business Services CC v. de Villiers, and others NNO 1991, 3, SA 552, T. Property mistakenly attached does not invalidate the warrant. Curbin 178, Proprietary, Limited v. Van den Heever and others NNO 2000, 4, SA 804, W. 811. The section should not be used where disputes over ownership are clear and open. Advanced Mining Hydraulics, Proprietary, Limited v. Botes No 2000, 1, SA 815, T. 822. Post-seizure possession. Once delivered to the trustee, ordinary legal principles determine possession rights. Curbin 178, Proprietary, Limited v. Van den Heever and others NNO 811-12. Books and documents on digital devices. Seizable under S69, LaRue and others v. Viana No, and others 2008, 2, SA 173, SCA. Notice to affected persons. Normally, audi alteram partem applies, but notice may be waived if it would defeat the purpose of seizure. Cooper No v. First National Bank of SA Limited 2001, 3, SA 705, SCA. Anti-dissipation orders. Used to prevent the removal of assets. Fay No v. Van de Vesthuizen, and others 2005, 2, SA 236, C. 249-50. Immovable property. Trustee has control of estate immovable property. Kahan No v. Hydro Holdings, Proprietary, Limited 1980, 3, SA 511, T. 514. May prevent unauthorized transfer via caveat entry in the Deeds Registry, S18b. Support for the insolvent. Before the second creditors' meeting, the trustee may provide financial support to the insolvent and dependents with the master's approval, S79. 11.3 Recovery of debts due to estate. Notification of debtors. The trustee calls for payments via public notice upon appointment, S77. No requirement for individual demands. No acceleration of future debts, only due debts must be paid. Settlement and composition of debts. Trustee may accept a partial settlement, S78-1. For debts above R2,000, trustee needs creditors or master's approval. George Hartman and K.V. Landros, Rights and Ander 1958, 4, SA 514, 0. Each debt must be individually assessed, no general settlement authority. Payment extensions. Trustee may extend payment deadlines, but not beyond the final date, for submitting the liquidation account, S78-1. Payments made to insolvent. Payments to the insolvent post-sequestration are void unless made in good faith, without knowledge of sequestration, S22. Next. Page 11.3 Continuation of insolvent's business. Trustee's authority. Trustee must realize estate assets quickly, and has no automatic right to continue the insolvent's business. Platskin v. Noble No 19, 15 AD 713, 717. May continue business only with creditor's authorization or master's approval if creditors do not provide instructions, S81. Liabilities and costs. Administration costs include costs of continuing the business, S97-2C. If a trustee continues business without authority, the estate is not liable for losses or extra expenditure. Consolidated Caterers Limited v. Patterson No 1960, 4, SA 194, E. Masters and Creditors Authority. Master may authorize business continuation before or after the second creditors' meeting, S81. Creditors can ratify ex post facto a trustee's unauthorized business continuation, Klatskin v. Noble no supra. Limits on continuation. Business can be continued only temporarily for winding up purposes, for example, preserving goodwill, Klatskin v. Noble no supra. Business cannot be continued indefinitely for profit, Dawn v. The Master 1964, 3 S. 838, N. 50-51. Marshall Brothers Trustee v. Transvaal Bank 1907 TS 1060, creditors cannot postpone asset sales indefinitely, or set a future sale date by resolution. Trustees' obligations if business continues. Must purchase goods for cash and use business takings unless creditors direct otherwise, S82. May employ necessary assistance to run the business, Klatskin v. Noble no supra, 717. Must prepare a trading account for business operations, C17, 1.2. _ 11.4 Investigation of insolvent affairs. Trustees' duty. Must investigate all pre-sequestration affairs and transactions of the insolvent, S81-1. Purpose: to report to creditors on the insolvent's affairs, transactions and any significant matters, see 11.7 for report details. Investigation tools. May require the insolvent to provide a written, detailed explanation of insolvency, and an accurate account of liabilities exceeding assets, S138B. Has the right to inspect and obtain certified copies of all the insolvent's income tax returns, S81-2. A certified tax return is admissible as evidence in any civil or criminal proceedings, S81-2. Next. Page 11.5 Receipt Book. Trustee's duty. Must open a receipt book immediately after appointment. Must record all money, goods, books, accounts, and documents received on behalf of the estate as soon as possible, S71-1. Inspection rights. The book may be inspected by the master, any creditor who has proved a claim, any person claiming to be a creditor or surety for the trustee, if the master orders it, S71-2. _ 11.6 Estate Bank Account. Trustee's obligation. Must open a check, current, account in the estate's name with a bank in the Republic, S71-A. Must deposit all estate money as soon as possible. If more than 40 South African rand is retained beyond the first possible deposit date, the trustee must pay double the retained amount into the estate, S72-1. Same penalty applies if the trustee knowingly allows a co-trustee to retain estate money, S72-1. Savings and investment. Surplus estate funds not immediately required for payments may be deposited into a savings account, or an interest-bearing deposit with a bank or mutual bank, S71-B, C. Master's oversight. The master may require the trustee to notify him in writing of the bank branch where the account is opened, S72. Provide a bank statement or proof of account status, S72. Not transfer the account to another branch without written notice, S73. Payment methods. S74 requires that all checks/orders drawn contain the payee's name and cause of payment. Be signed by all trustees or an authorized agent. Argument exists that electronic fund transfers, EFTs, are not permitted under S74, but Chief Master's Directive 5 of 2012 allows EFTs if payments are lawful and properly recorded. Payments only go to designated payee bank accounts. An affidavit under S3512 of the Administration of Estates Act 1965 may be used instead of a receipt for beneficiaries. Master's control over funds. Master and surety for the trustee have the right to inspect all estate banking records and vouchers, S75. Master may direct the bank manager to pay estate funds into the guardian's fund after notifying the trustee, S76. _ 11.7 Report to creditors. Trustee's duty. After investigating the insolvent's affairs, the trustee must submit a written report to creditors, S81-1. Timing of the report. at the second meeting of creditors, or at an adjournment of the second meeting, if the master grants written permission before the second meeting, or within 1 month after an offer of composition has been accepted. S81(1). Content of the report. Assets and liabilities of the insolvent. Cause of insolvency. Whether the insolvent kept proper business records and any deficiencies. Any contravention of insolvency law or other laws, including details of alleged offences. S81(4). Any allowances paid to the insolvent and the reasons for payment. Any business continued by the trustee, including goods purchased and trading results. Any pending or threatened legal proceedings against the estate. Any uncompleted acquisitions of immovable property or leases entered into by the insolvent. Any administration or realization issues requiring creditor direction. S81(1)(a)(i). Report circulation and approval. At least 14 days before the meeting, the trustee must send a copy of the report, the sheriff's inventory, the valuation of movable property to the master and creditors. S81(1) bis a. Must submit recommendations regarding resolutions or directions at the meeting. S81(1) bis a. At least 24 hours before the meeting, the trustee must submit an affidavit to the presiding officer, listing creditors' names and addresses, confirming the documents sent to creditors, detailing his recommendations. S81(1) bis b. Creditors' decision-making. Creditors may direct what action the trustee must take on reported matters. S81(3)(a). If no directions are given, the trustee's recommendations are deemed adopted with master's approval. S81(3)(b). The master may issue directions on any matter in the trustee's report. S81(3)(c). 11.8 Legal advice and proceedings. Engaging legal professionals. Trustee may hire an attorney or counsel for legal work, but must obtain prior written authorization from creditors, specifying the legal work, or the master if urgent or too many creditors exist. S73(1). If no estate surplus is expected, trustee can obtain ex post facto authorization from creditors. S73(1)(b). Legal costs. Legal expenses, including adverse cost orders, form part of the sequestration costs. S73(1). Legal fees are not subject to taxation if trustee agreed in writing to a specific fee tariff. No dispute exists over the agreed fees. S73(2)(3). Contingency fee agreements under the Contingency Fees Act 66 of 1997 are binding only if creditors expressly authorize the trustee in writing. S73(2) Insolvency Act. Master's power over legal costs. May disallow costs if the trustee acted in bad faith, negligently, or unreasonably. S73(5). Creditors' control over legal representation. A majority of creditors, by number and value, may direct the trustee on hiring a specific attorney. S53(5). If the trustee disagrees, he may refer the issue to the master, whose decision is final. S53(5). Effect of unauthorized legal actions. Trustee's failure to obtain authorization does not invalidate legal steps taken. Cf. Patel v. Perukes, Trustee 1944 AD 469, 475. Trustee is not personally liable for legal costs unless he acted in bad faith, negligently, or unreasonably. Cf. Re Estate Potgieter 19, 08TS 982. 11.9 Submission of disputes to arbitration. Trustee's power to arbitrate. May submit an estate-related dispute to arbitration, but must have creditor's authorization, or master's authorization if no creditor has proved a claim. S78(2). Other party to the dispute must consent to arbitration. S78(2). Next page. Chapter 12 Impeachable Dispositions. 12.1 Meaning of disposition. Defined in S2, includes any transfer or abandonment of rights to property, including sale, lease, mortgage, pledge, delivery, payment, release, compromise, donation, or any contract related thereto. Exclusion: dispositions made in compliance with the court order are not impeachable. Key interpretations. Property, S2, includes movable and immovable property within and outside the Republic. The sequestration order extends to foreign assets. 16 No v. Proudfoot S.A., Proprietary, Limited 2003, 4, SA 348, SCA. Repudiation of inheritance or insurance benefits does not qualify as a disposition. Wessels Novi de Jager 2000, 4, SA 924, SCA. Contracts as dispositions. Uncompleted dispositions. Estate Jager v. Whitaker 1944, AD 246. Suretyship contracts. Langeberg Corporacy BPKV in Verdorn Farming 1965, 2, SA 597, A. Issuing checks. De Villiers No v. Kaplan 1960, 4, SA 476, C. Third-party payments. Van Zel NNO v. Turner NNO 1998, 2, SA 236, C. Exclusion for court-ordered dispositions does not include fraudulent or collusive court orders obtained to prejudice creditors. Saxteen Inventor NNO v. Grayling 1990, 2, SA 323, O. Must occur before sequestration. The earlier the sequestration, the more transactions are subject to challenge. Afrism, South Africa, Proprietary Limited v. Mallet Investment Fund Proprietary Limited 2019, JDR 2519, SCA. 12.2 Dispositions that may be set aside. Dispositions can be voidable if they fall into the following categories. No value given, S26. Voidable preference, S29, prefers one creditor over others. Undue preference, S30, intend to prefer a specific creditor. Collusive disposition, S31, prejudices creditors or gives preference. Fraudulent disposition, Actio Palliana, fraud against creditors under common law. Until set aside by court, the disposition remains valid. Harcourt v. Eastman No 1953, 2, SA 424, N12, Cut 2.1 Disposition, made not for value, S26 Burden of proof. Trustee must prove 1. The insolvent made the disposition. 2. No value was received for it. 3. If the disposition was made more than 2 years before sequestration, the trustee must prove the insolvent's liabilities exceeded assets at the time, S26 1A. 4. If the disposition was within 2 years, the court must set it aside unless the recipient proves the insolvent's assets exceeded liabilities, S26 1B. Glenrand Mid Financial Services, Proprietary, Limited v. Van den Heever No 2012, JDR 2303, SCA. 5. The recipient of the disposition must have benefited. Van Wyk Van Heerden Attorneys v. Gorno 2022 Zasco 128. What constitutes value? Value means a benefit received or promised as a quid pro quo. Estate Jager v. Whitaker 1944 AD 246. Examples of no-value dispositions. Donations. Estate Jager v. Whitaker. Payments for unenforceable promises. Harcourt v. Eastman No 1953, 2, SA 424, N. Sales for nominal amounts. Bloom's Trustee v. Forey 1921 TPD 599. Examples of valid value. Debt payments considered valid because the payer receives a discharge of liability. Estate Jager v. Whitaker. Membership benefits. Example, maintaining membership in a gambling club. Estate Weggy v. Strauss 1932 AD 76. Performance under an illegal contract may still be value if the performance was actually rendered. Vis-a-vis Rousseau NNO 1990, 1, SA 139, A. Exclusions. Tax payments on fictitious income, not considered value. Commissioner for Inland Revenue v. Bowman No 1990, 3, SA 311, A. Interest paid on an illegal loan, considered a donation and voidable under S26, Engelbrecht Novi du Toy 2020 Zorch 119. This summary provides key case law, statutory provisions, and principles related to impeachable dispositions. Let me know if you need further breakdowns. Next. Page 12. 2. Disposition which prefers one creditor above another, voidable preference. What must be proved? Section 29(1). Court may set aside a disposition made by an insolvent within 6 months before sequestration or death, if estate is insolvent, if it prefers one creditor over another, if liabilities exceeded assets immediately after the disposition. Onus of proof lies with the trustee. Simon No and others v. Coetzee, 2007, 2 or SA 110, t. 112. Purpose of S29, prevent an insolvent from favoring some creditors over others. Disposition need not be direct. If the insolvent pays X instead of C, but X is a creditor of C, the disposition can be set aside. Standard Finance Corporation of SA Limited, in liquidation, v. Greenstein 1964, 3 SA 573, A. 577, Patterson No v. Trust Bank of Africa Limited 1979, 4 SA 992, A. Test for preference. Whether the disposition disturbs the proper distribution of assets. Whether the creditor received more or earlier than they would under normal insolvency proceedings. Isaacson and Son v. Van Drutens Trustee 1930 GWL 3336, Clerk No VK 1989, 3, SA 669, C. 675. Simon No and others v. Coetzee 114. Evidence of liabilities. Claims proved against the estate serve as prima facie proof of liabilities at sequestration. Ensor No v. New Mayfair Hotel 1968, 4, SA 462, N. Assessment of asset value. Market value should be considered. Defined as the price a willing seller could reasonably expect from a willing buyer. Venter v. Volksgas Limited 1973, 3, SA 175, t. 180. 2. Exception to S29, disposition in the course of business and not intended to prefer. Purpose of exception. Prevents S29 from discouraging businesspersons from continuing business, despite financial difficulties. Requirements: beneficiary must prove disposition was made in the ordinary course of business. No intention to prefer one creditor over another. S29(1), Janse van Rensburg and others NNO v. Steenkamp and another, Janse van Rensburg and others NNO v. Myburg and others 2010, 1, SA 649, SCA. Ordinary course of business. Objective test: whether solvent businesspersons would ordinarily enter into a similar transaction. Hendricks No v. Swanepoel 1962, 4, SA 338, A 345, Amalgamated Banks of SA BPK, Vida Huda NN Ander 1997, 4, SA 66, SCA 77, Ghazi Properties, Vubota and others NNO 2012, 2, SA 306, SCA 309. Considerations: whether the transaction conforms to ordinary business methods, whether it is anomalous and businesslike, or surprising. Maleb Trustee v. Dinner and others 1922, OPD 1822. Case examples: illegal pyramid schemes. Payments to investors in such schemes do not qualify as ordinary business transactions. Griffiths v. Janse van Rensburg and another NNO 2016, 3, SA 389, SCA Gainsford and others NNO v. Tanza Transport, Proprietary, Limited 2014, 3, SA 468, SCA. Customary business practices. The court considers business customs, for example, stock exchange transactions, bookmaker dealings. Hendricks No v. Swanepoel 345. Betting debts must be paid immediately under industry customs. Long outstanding payment not ordinary. Course of business. Estate Wege v. Strauss 1932 AD 7684. Specialized fields, transactions in specialized industries, assessed based on their specific norms. Hendricks No v. Swanepoel, Supra, 345. Key rulings on transactions in ordinary business. Valid contract payments. Even if business is illegal, payments under valid contracts may still be in the ordinary course. Bazi Properties, v. Bota, and others NNO 309/11. Regular payments. Payments made at arm's length over 4 months, with the last payment 2 months before liquidation, were in the ordinary course of business. Moodlino and others v. Lawson Tool Distributors, Proprietary, Limited 2022, SA 220, WCC. Forced transactions. Where the insolvent had no choice, transactions may be in the ordinary course. Pretorius Trustee v. Van Blomenstein 1949, 1, SA 267, 0. Bank force sale. When a bank forced an attorney to use sale proceeds to reduce an overdraft due to trust account theft. The transaction was not in the ordinary course. Patterson No v. Trust Bank of Africa Limited, Supra. Illegality exception. Both making and receiving the disposition must be lawful. Receiving usurious interest under a loan contract is not in the ordinary course. Clerk No v.K. 1989, 3, SA 669, c. No intention to prefer. What constitutes an intention to prefer? The insolvent must have intended to benefit a specific creditor. If the insolvent did not expect sequestration, no intent to prefer. Pretorius No v. Stock Owners Cooperative Co. Limited 1959, 4, SA 462, A 472, Van Eden's Trustee v. Pelinsky and Mervis, and others 1922, OPD 100, and 44 148. If dominant motive was something else, there is no intent to prefer. Shield from criminal prosecution or hide asset misappropriation. Pretorius Trustee v. Van Blomenstein 279-80. Fulfilling contractual obligations. Cooper and another NNO v. Merchant Trade Finance Limited 2000, 3, SA 1009, SCA. Hoping to survive financial difficulty is insufficient. Mere hope of financial recovery does not disprove an intention to prefer. Swanepoel No v. National Bank of SA 1923, OPD 3538. Distinguishing intent from motive is unhelpful. Courts focus on whether the debtor acted with the intent to prefer, rather than underlying motives. Moodlino and others v. Lawson Tool Distributors, Proprietary, Limited 2022, 2, SA 220, WCC. Next. Page 12.2-3 Disposition intended to prefer one creditor, undue preference. I. What must be proved? Section 30 allows the court to set aside a disposition if the insolvent made the disposition before sequestration. The intention was to prefer one creditor over others. The insolvent's liabilities exceeded his assets at the time. Burden of proof. The trustee must prove these elements. Venter v. Volksgas Limited 1973, 3, SA 175, T. 177. Once established, no defenses are available to the benefited creditor. Subjective test. The court determines the insolvent's intention based on whether their dominant, operative, or effectual intent was to disturb the fair distribution of assets in insolvency. The key issue is not whether the insolvent should have known the preference's effect, but whether they intended it as their primary objective. Eliasov No v. Arenal, Private, Limited 1979, 3, SA 415, R. 418. The insolvent must have applied their mind to the preference. If they did not consider it, they cannot be said to have intended it. Cooper and another NNO v. Merchant Trade Finance Limited 2000, 3, SA 1009, SCA 1029. Factors determining intention to prefer. Contemplation of insolvency. If the debtor foresaw sequestration as inevitable, intent to prefer is inferred. Duplessis No v. Oosthuizen NN Ander 1999, 2, SA 191, 0200, and 12-213. However, contemplation of insolvency does not always prove intent if other motives, for example, avoiding prosecution, are present. Praetorius Novi Stock Owners Cooperative Co. Limited 1959, 4, SA 462, A, 472-3. Debtor's free choice at time of disposition. If the debtor was under severe or terrifying pressure, intent to prefer may not be proved. Gore and others NNOV Shell South Africa, Proprietary, Limited 2004, 2, SA 521, C, 530. Not all pressure negates intent, only extreme forms akin to duress or undue influence. Lack of pressure or consideration does not automatically prove intent to prefer. Cooper and another NNOV Merchant, Trade Finance Limited, Supra, 1029. Relationship between debtor and creditor. A close friendship or family relationship may suggest intent to prefer, but is not conclusive. Praetorius Trustee v. Van Blomenstein 1949, 1, SA 267, O 279-280. Standard of proof. The court weighs all relevant facts and applies the balance of probabilities test. If multiple inferences exist, the most probable inference is chosen. If inferences favor both parties equally, the trustee has not discharged their burden. Cooper and another NNOV Merchant Trade Finance Limited, Supra 1027-1028. Failure of the insolvent to testify does not automatically imply intent to prefer. IBID 1028. 2. Differences between trustees' powers under Sections 30 and 29. Aspect Section 30, Undue Preference, Section 29, Voidable preference timing can be set aside regardless of when made before sequestration. Only applies to dispositions within 6 months before sequestration or death. Debtor's solvency. Debtor must be insolvent at the time of disposition. Can apply if the debtor was solvent when making it but became insolvent immediately afterward. Intent requirement. Trustee must prove actual intent to prefer a creditor. Trustee only needs to prove that the disposition had the effect of preferring a creditor. Defenses. No defenses available to the benefited creditor. Benefited creditor may raise statutory defenses. Next. Page 12.2-3 Disposition intended to prefer one creditor, undue preference. I. What must be proved? Section 30 allows the court to set aside a disposition if the insolvent intended to prefer one creditor over another. At the time of disposition, the insolvent's liabilities exceeded assets. Trustee has the burden of proof. Venter v. Volksgas Limited 1973, 3, SA 175, T. 177. No defenses are available to the benefited party once proof is established. Test for intention to prefer. Subjective test. Dominant or operative intention to disturb proper asset distribution in insolvency. Eliasov Novi Reno, Private, Limited 1979, 3, SA 415, R 418. Mere knowledge of conferring a preference is insufficient. Actual intention must be proven. Praetorius Trustee v. Van Blomenstein 1949, 1, SA 267, O 279. The insolvent must have applied their mind to the disposition. Cooper and another NNOV Merchant Trade Finance Limited 2000, 3, SA 1009, SCA 1029. Factors considered in proving intention to prefer. Contemplation of insolvency. If the insolvent realized sequestration was inevitable, the court infers intention to prefer. Duplessis Novi Orstes and N. Ander 1999, 2, SA 191, O. 212. Purpose other than preference. If the disposition was made to avoid criminal prosecution or exposure, preference intention is negated. Praetorius Novi Stock Owners Cooperative Co. Limited 1959, 4, SA 462, A 472-3. Freedom of choice. Payment under extreme pressure, akin to duress, may negate intention to prefer. Gore and others NNOV Shell, South Africa, Proprietary, Limited 2004, 2, SA 521, C. 530. Personal relationship between debtor and creditor. Close personal ties may indicate preference but are not conclusive. Praetorius Trustee v. Van Blomenstein 1949, 1, SA 267, O 279-80. Court's approach in determining intention to prefer. Weighs all relevant facts at the time of disposition. Balance of probabilities. If the most probable inference favors the trustee, the disposition is set aside. Cooper and another NNO v. Merchant Trade Finance Limited 2003, SA 1009, SCA 1027-8. 2. Differences between trustees' powers under Sections 30 and 29. Key distinctions between undue and voidable preferences. Undue preference, S30, applies at any time before sequestration. Voidable preference, S29, applies only if made within 6 months before sequestration. Insolvency at the time of disposition. Undue preference, debtor must be actually insolvent when disposition occurs. Voidable preference, debtor may be solvent at the time but must be insolvent immediately after. Burden of proof. Undue preference, trustee must prove actual intention to prefer. Voidable preference, trustee only needs to prove the disposition had the effect of preference. Defenses. No defense for undue preference. Voidable preference beneficiaries can raise defenses under S29. 12. 2.4 Collusive disposition prejudicing creditors or preferring one creditor. Section 31(1). Court may set aside a transaction where the insolvent colluded with another person to prejudice all creditors or prefer one creditor over others. Collusion requires fraudulent intent, not mere preference. Maino v. Transvaals Luendhor Corporatie BPK and Ander 1982. 4. SA 746, A. 771. Example. M and another v. Marino and others 2020. 6. SA 55, SCA. Debtor's sham divorce to transfer pension money to ex-wife was found to be collusive fraud. Requirements to succeed under S31(1). Disposition of property. Lono v. DMA Fishing Enterprises, Proprietary, Limited and another 2002. 2. SA 163, SE 165. Collusion with another person. Both parties must have known of insolvency and expected the disposition to harm creditors. Gert de Jager, Edens, BPK v. Jones no N. McCarty no 1964. 3 SA 325, A. 331. Prejudice to creditors or preference for one creditor. Lay no and another v. Harkson and others. 1998. For all SA 7. C. 15. Consequences of collusive disposition. Trustee can recover any loss caused to the estate. A penalty up to the benefit received by the guilty party. S31(2). Creditor involved in collusion forfeits any claim against the estate. Gert de Jager, Edens, BPK v. Jones no N. McCarty no 1964. 3. SA 325, A. 337. 12.2.5 Disposition in fraud of creditors. Actio Palliana, common law remedy allows creditors to set aside fraudulent dispositions outside the Insolvency Act. Swadeef, Proprietary, Limited v. Dyke no 1978. 1. SA 928, A 938. Still available even after debtor's liquidation. Amaropa Commodities, Proprietary, Limited v. Benchimol no 2020 JDR 1223, KZD, Para 24. Requirements for the Actio Palliana. The transaction diminished the debtor's assets. The recipient did not receive their own property. Intention to defraud creditors. The fraud took effect. Hockly no v. Rixon no and Smith 1939, SR 107 118. Definition of fraud. Not in the criminal sense. Objective, giving one creditor an unfair advantage. Trustees Estate Chin v. National Bank of South Africa Limited 1915, AD 353 363. Different burdens of proof depending on type of disposition. Dispositions for value. Onerous title. Insolvent must have intended fraud, and the recipient must have known about it. Pharmaceutical Enterprises, Proprietary, Limited v. Main Road Centurion 30200, and 1 CC 2021, 5, SA 246, GJ 251. Gratuitous dispositions. Lucrative title. Proof of fraud by the insolvent alone is sufficient. Recipient's good faith is irrelevant. Hockly no v. Rixham and Smith 1939, SR 107 119. Examples of fraudulent transactions. VUT 42.8.15. Granting a long lease at very low rent. Allowing prescription of a claim. Selling, donating, or pledging property for another's debt. Becoming liable for a non-existent debt. Creditors can recover the alienated asset itself. Any benefits derived from its fraudulent use. Corbin 178, Proprietary, Limited v. Van den Heever and others NNO 2000, 4, SA 804, W, 818-20. Next. Page 12, 2.4 Collusive disposition, which prejudices creditors or prefers one creditor. Legal basis. Section 31(1). The court may set aside a transaction where a debtor, in collusion with another person, disposed of property in a way that prejudiced creditors or preferred one creditor over another. Collusion defined requires fraudulent intent, not merely an agreement that results in preference. Maino v. Transvaals Loonhawk Cooperatie BPKN Ander 1982, 4, SA 746, A, 771. Key cases. M and another v. Murray No and others 2020, 6, SA 55, SCA. Debtor attempted to shield pension money from creditors. Divorce settlement granting most assets to the spouse was found to be a sham and collusive. Requirements for setting aside a collusive disposition. 1. Disposition of property. Debtor must have transferred property. Lono v. DMA Fishing Enterprises, Proprietary, Limited and another 2002, 2, SA 163, SE 165. 2. Collusion with another person. Both parties knew the debtor was insolvent and intended to prejudice creditors or prefer one over another. Gert de Jager, Edens BPK v. Jones No N. McCarty No 1964, 3, SA 325, A, 331. 3. Prejudicial effect on creditors. Disposition must harm creditors or unfairly prefer one creditor. Lane No and another v. Harkson and others, 1998, for all SA 7, C, 15. Consequences of collusive dispositions, Section 31(2) and 3. Trustee may recover any loss caused to the insolvent estate. A penalty determined by the court, not exceeding the benefit received. Creditor's forfeiture. If the other party is a creditor, they lose any claim against the estate. Gert de Jager, Edens, BPK v. Jones No N. McCarty No, Supra, 337. 12.2.5 Disposition in fraud of creditors, Actio Palliana legal basis. Common law remedy. Even if the Insolvency Act does not apply, creditors can invoke the common law remedy of Actio Palliana, Swadif, Proprietary, Limited v. Dyke No 1978, 1, SA 928, A 938. Originates from Roman law, and is used to recover assets fraudulently removed from an insolvent estate. Still available after debtor's liquidation. Amaropa Commodities, Proprietary, Limited v. Benchimol No 2020 JDA, 1223, KZD, Para 24. Requirements for Actio Palliana. 1. Diminution of debtor's assets. Transaction must have reduced the debtor's estate. 2. Recipient did not receive own property. Property transferred did not belong to the recipient. 3. Intent to defraud. Transaction aimed to defraud creditors. 4. Fraud took effect. The fraudulent transfer was successful. Hockly no v. Wrexham no and Smith 1939 SR 107-118. Key legal principles. Fraud defined. Not criminal fraud, but an unfair advantage to one creditor over others. Trustees Estate Chinvi, National Bank of South Africa Limited 1915 AD 353 363. Disposition for value, ex titulo oneroso. Both debtor and recipient must have fraudulent intent. Hockly no v. Wrexham and Smith, Supra, 119. Gratuitous disposition, ex titulo lucrativo. Only the debtor's fraudulent intent is required. Recipient's good faith is irrelevant. Shafts Trustee v. Shaft 1915 TPD 463. Examples of fraudulent transactions. Voot 42.8.15, Mars the law of insolvency. Long-term lease at an unreasonably low rental. Allowing a claim to prescribe. Failing to defend a groundless legal action. Selling, gifting, or pledging property for another's debt. Acknowledging a non-existent debt. Recovery under Actio Palliana. Creditors can recover assets disposed of fraudulently. Benefits gained from the fraudulent transaction. Curbin 178, Proprietary, Limited v. Van den Heever and others NNO 2000, 4, SA 804, W, 800, and 18-20. Next. Page 12, 2.4 Collusive disposition, which prejudices creditors or prefers one creditor. Section 31(1). The court may set aside a transaction where the debtor colludes with another person to dispose of property in a way that prejudices creditors, or prefers one creditor over another. Collusion requires a fraudulent agreement, not merely an agreement that results in preference. Maino v. Transvaals Lewendhall Corporacy, BPKN, Under 1982, 4, SA 746, A, 771. Example, M and another v. Marino and others 2026, SA 55, SCA. Debtors' sham divorce and settlement agreement were collusive. Requirements to succeed under Section 31(1). Disposition of property by the insolvent, Lono v. DMA Fishing Enterprises, Proprietary, Limited and another 2002, 2, SA 163, SE 165. Collusion. Both parties must have known about the insolvency and expected the disposition to affect creditors. Gert de Jager, Edens, BPK v. Jones no N. McCarty no 1964, 3 SA 325, A 331. Prejudicial effect. Disposition must result in prejudice or preference. Lane no and another v. Hodgson and others, 1998. For all SA 7, C. 15. Consequences of collusive disposition. Trustee may recover loss caused to the insolvent estate. A penalty not exceeding the amount the party benefited, S. 31(2). Creditors involved in collusion forfeit claims against the estate, S. 31(2), Gert de Jager Case 337. 12.2.5 Disposition in fraud of creditors, Actio Palliana, common law remedy. Creditors can challenge fraudulent dispositions beyond statutory provisions. Swadif, Proprietary, Limited v. Dyke no 1978, 1, SA 928, A, 938. Actio Palliana, derived from Roman law, allows recovery of assets that should have been in the estate. Amaropa Commodities, Proprietary, Limited v. Benchimol no 2020 JDR, 1223, KZD, Para 24. Requirements for Actio Palliana. The transaction diminished the debtor's assets. The recipient did not receive his own property. There was an intention to defraud. The fraud took effect. Hockly no v. Wrexham no and Smith 1939, SR 107-118. Concept of fraud in this context. Not necessarily criminal fraud, simply a transaction giving unfair advantage to one creditor. Trustees Estate v. National Bank of South Africa Limited 1915, AD 353-363. Disposition for value, ex titulo oneroso, requires fraudulent intent by the insolvent and knowledge of it by the recipient. Pharmaceutical Enterprises, Proprietary, Limited v. Main Road Centurion 30,200, and 1 CCTA Mall Pharmacy, and another 2021, 5, SA 246, GJ, 251. Gratuitous disposition, ex titulo lucrativo, only fraud by the insolvent needs to be proven. Shafts Trustee v. Shaft 1915 TPD 463. Examples of fraudulent transactions, VOOT 42.8.15. Leasing property at an unreasonably low rent, allowing a debt to become prescribed, selling or pledging property for another's debt. Recovery under Actio Palliana. Creditors may reclaim alienated assets and benefits derived from them. Curbin 178, Proprietary, Limited v. Van den Heever and others, NNO 2000, 4, SA 804, W, 818-20. 12.3 Proceedings to set aside voidable dispositions. 12.3.1 Who may sue? Trustee may sue to set aside dispositions or recover penalties, S32(1)(a). If the trustee fails to act, a creditor may sue in the trustee's name, provided the creditor indemnifies the trustee against all costs, S32(1)(b). Myber v. Walters No 2001, 2, SA 127, C. 130. Indemnity must be adequate, and given before proceedings begin. Lane and another NNO v. Dabblestein and others 1999, 3, SA 150, C. 163-6. If provided late but the trustee is never at risk, it may still be valid. Cowan v. Hathorne No 2013, JDR 2671, SCA. Procedure for creditor lawsuits. Trustee must be cited as the nominal plaintiff. Volkskas BPK No v. Barclays Bank, DC&O, 1955, 3 SA 104, T. Priority of recovering costs. The litigating creditor is paid first, S 104-3. Creditors delaying claim proof cannot share in recovered assets, S 104-2. Actio Palliana, trustee sues, but a creditor may be permitted to sue if the trustee is joined as a party. Volpe v. Gale 1980, 3, SA 259, W 12.3, to jurisdiction of court. Magistrates' Court has jurisdiction if within monetary limits, S2 SV Court. 12.3.3 Time for bringing proceedings. No time limit for bringing an action under S32(1). Proceedings may be instituted even after liquidation and distribution account is confirmed. Cookno v. S.J. Kutsia Incorporated 2012, 2, SA 616, GNP, 622. 12.3.4 Interim relief. Trustee may apply for attachment of the property pending the outcome of proceedings. Hawkins Trustee v. Carlisle Saw and Planing Mills Limited, and others 1923 WLD 125. Trustee must show a prima facie case but not irreparable loss, IBID. Interim proceedings. Creditors may act in their own name in urgent cases. Ultrapolymers, Proprietary, Limited v. Marino, and another 2012, 4, SA 232, GSJ, 234-5. Next. Page. 12.3 Proceedings to set aside voidable disposition. 12.3.1 Who may sue? Proceedings to set aside an impeachable disposition or recover compensation/penalty may be instituted by the trustee, S32(1)(a). If the trustee fails to act, a creditor may sue in the trustee's name, but must indemnify the trustee against all costs, S32(1)(b). Myberg v. Walters No 2001, 2 SA 127, C. 130. Indemnity protects the estate from adverse costs. Lane and another NNO v. Dabblestein and others 1999, 3, SA 150, C. 163-6, indemnity must be provided before action and be adequate. Western Flyer Manufacturing, Proprietary, Limited v. Durance and others NNO 2007, 6, SA 459, B, 465, 470, proceedings without prior indemnity, are irregular but not necessarily invalid. Dabblestein and others v. Lane and Fay NNO 2001, 1 SA 1222, SCA 1229, creditor does not need court leave to sue under S32 if indemnity is provided. Cowan v. Hathorne No 2013 JDR 2671, SCA, indemnity ensures liquidators are not liable for costs when creditors litigate in their name. A creditor must cite the trustee as the nominal plaintiff. Suing in their own name is not competent. Volkskas BPK No v. Barclays Bank, DC and O, 1955, 3, SA 104, T. No other creditor benefits from recovered property until the litigating creditor's claim and costs are paid, S 104, 3. A creditor who delays proving a claim until after judgment cannot share in the recovery, S 104, 2. The trustee is the proper person to institute actio palliana at common law, Walke v. Gale 1980, 3, SA 259, W. A creditor may sue in their own name if the trustee is joined as a co-plaintiff or co-defendant. 12.3 To jurisdiction of court. Magistrates' Court has jurisdiction to hear proceedings if within jurisdictional limits, S2 SV Court. 12.3.3 Time for bringing proceedings. No time limits on the trustee's power to bring proceedings under S32(1). Proceedings can continue even after liquidation and distribution account confirmation, S112. Cook No v. S.J. Kutsia Incorporated 2012, 2, SA 616, GNP, 622. Confirmation under S112 does not affect S32 claims. 12.3.4 Interim relief. If impeachable property is in creditor's possession, trustee may apply for attachment pending proceedings. Hawkins Trustee v. Carlisle Saw and Planing Mills Limited and others 1923, WLD 125. Trustee needs to show prima facie case for reclaiming property, not irreparable loss. Interim proceedings do not require suing in the trustee's name. Ultra Polymers Proprietary, Limited v. Maridi No and another 2012, 4, SA 232, GSJ, 234-5, creditors may act in their own name in urgent cases. Next page. 12.3.5 Evidence. Section 32(2) of the Insolvency Act allows any party to subpoena the insolvent to give evidence in proceedings to set aside an improper disposition. The court may also call upon the insolvent to testify. The insolvent cannot refuse to answer questions on the grounds that the response may be self-incriminating. Constitutional concerns. The Constitutional Court in Pabo, and others v. Getz No and another 1997, 4, SA 1095, CC, ruled that compelling self-incriminating testimony violates Section 35 of the Constitution, right against self-incrimination. The ruling declared invalid S. 415(5) of the Companies Act 61 of 1973, which allowed for the admission of self-incriminating evidence in criminal proceedings, except for perjury or related offenses. Discovery in legal proceedings. If a creditor initiates proceedings in the trustee's name, only the trustee may make discovery under the Uniform Rules of Court, Reynolds and others NNOV Standard Bank of South Africa Limited 2011, 3 SA 660, W. 662-3. Underscore. 12.3.6 Prescription of Claim. Barnard and Lynn NNOV Schumann, and another 2000, 3, SA 168, N 171-2. Held that a claim to set aside an impeachable disposition is not a debt for the purposes of prescription. Prescription does not begin to run until the court determines the value of the claim and rules on possible defenses. Duet and Magnum Financial Services CC, in liquidation, v. Costa 2010, 4, SA 499, SCA 505-8. Rejected the Barnard decision. Held that sections 26 to 31 and 32(3) of the Insolvency Act give the trustee the right to have a person declared a debtor of the estate. This right qualifies as a debt for prescription purposes. Prescription begins to run no later than the date of the trustee's or liquidator's appointment. 12.4 Order setting aside disposition. 12.4.1 Recovery of property alienated. Section 32(3). If a disposition is set aside, the court must declare the trustee entitled to recover either the property alienated or the value of the property at either the date of the disposition or the date the disposition is set aside, whichever is higher. 12.4.2 Execution on court's judgment. Trustee's enforcement rights. Once judgment is granted, the trustee is in the same position as a judgment creditor, De Hartno v. Clayhans, and others 1970, 4, SA 383, 0389. If the defendant does not comply, the trustee can use normal execution processes. Mora interest. The defendant must pay mora interest, compensating for wrongful delay in performance, from the date of judgment. Janse van Rensburg, and others NNO v. Stain 2012, 3, SA 72, SCA 80-1. Sequestrated defendant. If the defendant is under sequestration, the trustee cannot claim full payment, but must prove as a concurrent creditor in the estate. Ibid. Pride Milling Company, Proprietary, Limited v. Becker No and another 2022, 2, SA 410, SCA. Concern the application of Section 341(2) of the Companies Act 61 of 1973, which states, any property disposition, by a company being wound up after winding up commencement, is void unless the court orders otherwise. Court's discretion can validate such dispositions in exceptional cases based on fairness, limited to payments made between the lodging of the winding up application and the provisional winding up order, point of concursus creditorum. 12.4.3 Indemnity to bona fide recipient of disposition. Section 33(1). A bona fide recipient of a voidable disposition need not return the property, unless indemnified by the trustee. Requirements. Onus on recipient. Must prove that, in return for the disposition, they parted with property/security or lost a right against another person. Ruskin No v. Barclays Bank DCO 1959, 1, SA 577, W. There must be reciprocity between what was given and received. Barclays National Bank Limited v. Umbogantwini Land and Investment Company, Proprietary, Limited in liquidation, and another 1985, 4, SA 407, D. Section 33(1) does not apply if no property was parted with. There is only an incidental connection. Consolidated News Agencies, Proprietary, Limited in liquidation, v. Mobile Telephone Networks, Proprietary, Limited and another 2010, 3 SA 382, SCA 398. Good faith requirement. The recipient must have genuinely believed the transaction was legitimate. They must not have known of the debtor's insolvency. Ruskin No v. Barclays Bank DCO, Supra, 584-5. Purpose of Section 33(1). Ensures restitutio in integrum, restoration of both parties to predisposition positions. Barclays National Bank Limited v. Umbogantwini Land and Investment Company, Proprietary, Limited in liquidation, and another Supra, 411. Trustee's obligation. Trustee cannot enforce the return of the property unless an indemnity is provided. Ruskin No v. Barclays Bank DCO, Supra, 583. 12.4.4 Effect of order on underlying debt. Effect of setting aside a disposition on debt obligations. Gratuitous dispositions, Section 26. The debt is extinguished. The beneficiary cannot claim against the estate. A surety for the insolvent is discharged. Linden Duplex, Proprietary, Limited v. Harrowsmith 1978, 1, SA 371, W. Voidable preferences, Section 29. Conflicting judgments. Friedman and Rossi, Proprietary, Limited v. Houston and others 1986, 4, SA 762, W. Setting aside the disposition extinguishes the debt. Millman No and Stein No v. Camphor, Millman No and Stein No v. Engelbrecht 1993, 1, SA 305, c. The debt remains, only the unusual performance is prohibited. The beneficiary can claim against the estate. A surety remains liable. Undue preferences, Section 30, and collusive dispositions, Section 31. Courts have not clarified the effect of setting aside on the underlying debt. However, Section 31(2) states that a creditor party to a collusive disposition forfeits any claim against the estate. Gert de Jager, Edens. BPK v. Jones No N. McCarty No 1964, 3 SA 325, A. 337. Unresolved legal position. The Supreme Court of Appeal has not yet settled whether setting aside any impeachable disposition, under Sections 26 to 31, should have a uniform effect on debt extinguishment. Next. Page 12.5 Exemption of certain dispositions from the Act. Some dispositions are exempt from the provisions of the Insolvency Act. Sections 26, 29, and 30, dispositions without value, voidable preferences, and undue preferences, do not apply to property disposed of under exchange rules, depository rules, or clearinghouse rules, S35A5, property disposed of in terms of a master agreement, S35B4. See also 7, 2.9 to 10. Under S35(2)A of the Prevention of Organized Crime Act 100 and 21 of 1998, if a defendant's estate is sequestrated. The court must not set aside an affected gift under SS 29, 30, or 31 of the Insolvency Act if a prosecution for an offense has been instituted and proceedings are ongoing. The recipient's property is subject to a restraint order. If a court does set aside a disposition after the proceedings conclude, it must consider any realization of the recipient's property under Chapter 5, which deals with proceeds of unlawful activities, S35(2)B. 12.6 Transfer of business without prescribed notice. General Rule, S34(1) of the Insolvency Act, a trader who transfers a business, its goodwill, or any part of its assets without the prescribed notice. The transfer is void against creditors for 6 months. If the trader's estate is sequestrated within 6 months, the transfer is void against the trustee. Transfer includes both actual and constructive possession, S34(4), applies regardless of the nature of the preceding agreement. Ruse No N. Ander v. Kevin and Lacier Property Investments BKN and De, 2002, 6, SA 409, T. 415. Publication requirements. The trader must publish a notice of intended transfer in the Government Gazette, 2 issues of an Afrikaans newspaper, 2 issues of an English newspaper circulating in the business district. Timing, at least 30 days and not more than 60 days before the transfer. The notice must provide accurate information, incorrect dates invalidated. Simon v. DCU Holdings, Proprietary, Limited and others 2003, SA 202, T. 226. Even if creditors know about the transfer, publication is still required. Gainsford and others NNO v. Tifsky Property Investments, Proprietary, Limited and others 2012, 3, SA 35, SCA 42. Effect on liabilities, S34(2). Once notice is published, all liquidated liabilities of the trader that would be due in the future become immediately due if creditors demand payment. Scope and interpretation of S34(1). Objective: protect creditors from traders who evade debts by selling a business and dissipating the proceeds. The section applies even if the trader's estate is not sequestrated. For Mark v. Joubert and May 1993, SA 866, A 873. The sale was advantageous, i.e., assets sold above value. Joseph v. Ensor No 1966, 1, SA 319, A 326-7. Applies only to traders. A trader is defined under S2 as someone conducting a specified business activity. C 4.2. Includes businesses involved in buying, selling, manufacturing, or exchanging property. Excludes leasing immovable property. Kevin and Lacia Property Investment CC, and Another v. Rusno and Others 2004, 4, SA 103, SCA 108, and Transport Haulage, McCarthy Limited v. Gorno 2007, 6, SA 366, SCA 370. Determining if a person is a trader. The core business is key. McCarthy Limited v. Gorno, Supra, 370-1. The burden of proof is on the person alleged to be a trader. Gainsford and Others NNO v. Tifsky Property Investments, Proprietary Limited and Others, Supra, 44. The status of the trader is assessed at the date of transfer. K2013046547/07, South Africa, Proprietary Limited v. Hyde Construction CC 2021 JDR 1210, SCA, Parrot 13. A trader remains a trader even if they have stopped operating. Calvin Park Properties CC v. Patterson No 2001, 3, SA 31, SCA, 35. Partial transfers covered. Includes transfer of goodwill, goods or property forming part of a business. Joseph v. Ensor No Supra. Even if the goods were not physically appropriated to the business, they may still be covered. Transfers exempt from S34(1). Transfers in the ordinary course of the business must be assessed based on similar businesses in similar circumstances. Ensor No v. Rinsco Motors, Proprietary, Limited 1981, 1, SA 815, A 825. A contractually obligated sale may qualify. Ensor No v. Rinsco Motors, Proprietary, Limited, Supra, 826. A transfer to secure the payment of a debt, for example, a pledge, is not covered. Burden of proof. If a trustee claims S34(1) applies, they must prove the goods formed part of the business at the time of transfer. Silverstream Investments, Kranskop, CCV Ronbo Automotive CC 1997, 1, SA 107, B 111. The transfer was not in the ordinary course of business. Ensor No v. Rinsco Motors, Proprietary, Limited, Supra, 822. Legal consequences of non-compliance. An advertised transfer is void against the trustee. The trustee may demand the return of assets without court action. Harrismith Board of Executors v. Oerdendahl, Supra, 538-9. If resisted, the trustee must seek a court order declaring the transfer void. Scott Hayward No v. Leaf No 1958, 3, SA 65, T. If assets were resold, the trustee may claim their value. War and Another NNO v. Safican Industrial, Proprietary, Limited, Supra. Effect on mortgage bonds. If a trustee invalidates the transfer, any mortgage bond registered by the transferee over the property also becomes void. Reasoning: the transfer was void ab initio, from the beginning, so the transferee never acquired ownership, and could not encumber the property. Gainsford and Others NNO v. Tifsky Property Investments, Proprietary, Limited and Others, Supra, 45-9. This does not violate S25(1) of the Constitution. Transfer void against creditors. Creditors can disregard the transfer for debt recovery. Pharmaceutical Enterprises, Proprietary, Limited and Others v. Main Road Centurion 30,200, and 1 CCTA Albemarle Pharmacy, and Another 2021, 5, SA 246, GJ, 250. This summary includes the key legal principles, case law, and statutory provisions governing exempt dispositions and transfers of business without notice under the Insolvency Act. Next. Page 12.7 Transfer of business after proceedings instituted. Key provisions of Section 34(3) applies when a trader transfers a business after legal proceedings have been instituted against them regarding claims connected to the business. Transfer is void against the claimant if the transferee knew about the proceedings at the time of transfer. The proceedings were instituted in a high court or magistrate's court, with jurisdiction over the district where the business operates. Key case law and interpretations. Applicability regardless of notice requirement. Simon v. DCU Holdings, Proprietary, Limited and Others 2003 SA 202, T. 222. Section 34(3) applies even if the trader complies with the notice requirements of S. 34(1). Creditors' protection without judgment. Wealthman's Custom Office Furniture, Proprietary, Limited, in liquidation, v. Whistler CC 1999, 3, SA 1116, SCA 1121. Protection applies if proceedings were instituted before transfer, even if judgment was not yet obtained. No time limitation on protection. Summa v. Avon Lee CCTA LC Products 2001, SA 524, E. 528-9. Section 34(3) is not time-limited. Creditors can enforce their claims indefinitely. Claims must be in connection with the business. Simon v. DCU Holdings, Proprietary, Limited and Others, Supra, the phrase in connection with the business should not be interpreted narrowly. Includes claims for the balance of the purchase price of business assets. Axel Properties 2 CC v. Kotzer 2013 JDR 2086, SCA, Para 18, 21. A claim not linked to the trader's primary/core business is excluded. Amended or superseded agreement still protected. Wealthman's Custom Office Furniture, Proprietary, Limited, in liquidation, v. Whistler CC, Supra, 1122. If the original agreement is replaced by a settlement agreement, the claim still falls under S. 34(3) if closely connected. Malansky Asia, a compromise does not change the essence of a claim if both agreements concern the same business transaction. Transfer is void only against the claimant. Wealthman's Custom Office Furniture, Proprietary, Limited, in liquidation, v. Whistler CC, Supra, 1123. The transfer is not entirely void, but void only as against the creditor and to the extent of their claim. 12.8 Suggestions for visual learners using diagrams and timelines. Understanding the parties, roles, and time requirements is crucial in legal cases. Kevin and Lacia Property Investment CC, and Another v. Rusno and Others 2004, 4, SA 103, SCA. This case illustrates the consequences of failing to publish notice under S. 34(1). Timeline of events under Section 34(1). Publication period must be at least 30 days but not more than 60 days before the transfer. Voidness period. If the notice requirement is not met, the transfer remains void against creditors for 6 months after the transfer. If the trader is sequestrated within this period, the transfer is void against the trustee as well. Kevin and Lacia case timeline. LFH, Proprietary, Limited failed to publish the notice, XXX show missing publication. 6-month period calculated based on the Interpretation Act 33 of 1957. Transfer date, the 29th of June. Voidness period, the 29th of December. Liquidators met the time requirement to have the transfer set aside. Next. Page 12.7 Transfer of business after proceedings instituted. Section 34(3) Overview. Applies when a trader transfers a business after another person, has instituted legal proceedings to enforce a claim related to that business. The transfer is void against the creditor for enforcement purposes if the transferee was aware of the instituted proceedings at the time of transfer. The proceedings were instituted in a high court or magistrate's court with jurisdiction over the business location. Key points on Section 34(3). Notice under Section 34(1) is irrelevant. Section 34(3) applies regardless of whether the trader gave notice of the transfer. Simon v. DCU Holdings, Proprietary, Limited and Others 2003, SA 202, T. 222. No judgment required. The creditor is protected if proceedings were instituted before transfer, even if no judgment was obtained. Wealthman's Custom Office Furniture, Proprietary, Limited, in liquidation, v. Whistler CC 1999, 3 SA 1116, SCA 1121. No time limit on protection. The protection is not restricted by time. Suma v. Avon Lee CCTA LC Products 2001, SA 524, E. 528-9. Must be a business-related claim. The claim must relate to the business. Claims unrelated to the trader's business do not qualify. Broad interpretation includes claims for unpaid balances on the sale of business assets. Simon v. DCU Holdings, Proprietary, Limited and Others, Supra. The nature of the business and the creditor's claim determine relevance. Axel Properties 2 CC v. Coxa 2013 JDR 2086, SCA. Para 18. A claim not related to the trader's core business is excluded. Edom Para 21. Amended or superseded agreements. Protection under S34(3) extends to claims based on agreements, replacing an earlier agreement, provided there is a close connection between the two. Wealthman's Custom Office Furniture, Proprietary, Limited, in liquidation, v. Whistler CC, Supra. A settlement agreement replacing an original sale agreement was still considered sufficiently connected, as both involved the same business and claim for payment. Edom 1122. Partial voidness. The transfer is not entirely void, but is void against the creditor to the extent of their claim. Wealthman's Custom Office Furniture, Proprietary, Limited, in liquidation, v. Whistler CC, Supra 1123. 12.8 Visual Learning with Diagrams and Timelines. Understanding roles and timeframes, identifying parties involved, their roles and statutory deadlines is crucial. Illustration with Kevin and Lacia Property Investment CC, and another v. Rousseau and Others 2004, 4, SA 103, SCA, case discussed in Section 12.6 regarding failure to give prescribed notice under S34(1). Facts and decision covered in Para 12.6, 4th bullet. Visual representation of Section 34(1) timeframes. Publication period for notice. Too early, more than 60 days before transfer, triple excess before first notch. Too late, less than 30 days before transfer, triple excess after second notch. Voidness period, if notice not given. Transfer is void against creditors for 6 months. Transfer also void against trustee if the trader's estate is sequestrated within this period. Example timeline, Kevin and Lacia case. LFH, Proprietary, Limited never published the notice. 6-month period after transfer calculated as per Interpretation Act 33 of 1957. Liquidators acted within the required timeframe to set aside the transfer. Next page. Chapter 13 Interrogation of the Insolvent and Other Witnesses. Synopsis. 13.1 Interrogation by trustee, or creditor or presiding officer. 13.1.1 When and where interrogation may take place. 13.1.2 Who may be interrogated. 13.1.3 Who may interrogate. 13.1.4 Subject matter of interrogation. 13.1.5 Procedure at interrogation. 13.1.6 Privilege. 13.1.7 Failure to attend or submit to interrogation. 13.1.8 Interrogation revealing possible offense. 13.2 Interrogation by master. Overview. The Act allows interrogation of the insolvent and other witnesses to investigate the insolvent's affairs and financial position. The trustee and creditors can interrogate witnesses, while the master may conduct a private interrogation. A trustee failing to conduct a formal interrogation, when required, is guilty of dereliction of duty. Thorn v. the Master 1964, 3 SA 38, N 52-3. 13.1 Interrogation by trustee, or creditor or presiding officer. 13.1.1 When and where interrogation may take place. Interrogation may be conducted at any meeting of creditors, S65-1, including a special meeting for proof of claims, Luba v. Estate Luba 1935 CPD 299, a general meeting for giving directions to the trustee, Assault v. the Master and another 1983, 1, SA 926, c. The meeting must be properly called. Not valid if solely for interrogation, Assault v. the Master and another supra. If the stated purpose is different but actual intent is interrogation, it is invalid. Marks and another v. de Villiers and another NNO 1990, 4, SA 415, W, 13.1.2, who may be interrogated. Insolvent and any other person who has been or might have been summoned under S64-2. Persons who may be summoned, S64-2. Anyone known or reasonably believed to possess property belonging to the insolvent or their spouse. Anyone known or reasonably believed to be indebted to the estate. Anyone capable of providing material information about the insolvent's affairs, estate, or spouse's business. Persons may also be summoned to produce books or documents, S64-3. The person must actually produce the document, not just allow access, Pizzolady v. Van Rensburg and others NNO 2002, 2, SA 160, SE 162. The range of possible witnesses is broad to allow a thorough investigation, Janulis v. Grobler, and others 1963, 1, SA 599, T 601. Limitations on subpoenas. Must remain within permissible investigative scope, cf. Pizzolady v. Van Rensburg and others NNO supra. Attendance requirements. Insolvent must attend the first and second creditors' meetings unless excused by the presiding officer, S64-1. Trustees' permission required for absence. Allowances. Insolvent/spouse entitled to necessary expense coverage, S65-8. Other summoned persons entitled to witness fees, S65-7. 13.1.3 Who may interrogate. Trustee. Any creditor who has proved the claim. Presiding officer. Agents of any of the above, S65-1. 13.1.4 Subject matter of interrogation. Scope, S65-1. Insolvent's business, affairs, or property, before or after sequestration. Any property belonging to the estate, business, affairs, or property of the solvent spouse. Purpose. Obtain a detailed picture of the insolvent's financial position. Permissible to hold interrogations to gather information for civil litigation. Pizzolady v. Van Rensburg and others 2002, SA 160, SE 161-2. Constitutional considerations. Challenge in Hodgson v. Lane No and others 1998, 1, SA 300, CC, argued that S65-1 violated fundamental rights, equality, property, privacy, freedom/security of person. Court upheld S65-1. Solvent spouse's property vests temporarily in the master or trustee, thus interrogation is valid. Questions must be relevant to the insolvent estate. Presiding officer cannot force answers that violate constitutional rights. If a question infringes constitutional rights, it is not lawfully put, and refusal to answer is not punishable, citing Nell v. LaRuno and others 1996, 3, SA 562, CC. Key cases: Thorn v. the Master 1964, 3 SA 38, N. 52-3, trustee failing to conduct formal interrogation is guilty of dereliction of duty. Luba v. Estate Luba 1935 CPD 299, special meeting for proof of claims valid for interrogation. Asop v. the Master and another 1983, 1, SA 926, C. Meeting cannot be called solely for interrogation. Marks and another v. de Villiers and another NNO 1990, 4, SA 415, W. Stated purpose of a meeting must match its actual intent. Pizzolady v. Van Rensburg and others NNO 2002, 2, SA 160, SC. Subpoenaed persons must produce required documents. Broad interrogation scope is valid. Yanulis v. Grobler and others 1963, 1, SA 599, T 601, extensive range of witnesses permissible. Harkson v. Lane No and others 1998, 1, SA 300, CC. Section 65(1) not unconstitutional. Presiding officer cannot force unconstitutional questions. If a question violates fundamental rights, refusal not punishable. Now v. LaRue and others 1996, 3 SA 562, CC. If a question infringes constitutional rights, it is not lawfully put. Conclusion. Interrogation ensures full disclosure of the insolvent's financial position. Meetings must be properly convened for interrogation to proceed. Broad range of witnesses and documents may be summoned. Scope of interrogation is extensive, allowing creditors to investigate all relevant financial affairs. Legal safeguards exist against unconstitutional questioning. Next. Page 13.1.5 Procedure at Interrogation. Authority and Oath. The presiding officer may call and administer the oath to the insolvent or other witnesses for interrogation, S65(1). Purpose: no pre-formulated issues. Inquiry aims at discovery for financial benefit to the estate. Agirakis v. Gunn 1963, 1, SA 602, T. 604, Grapentine v. Sumaginnis Communications, CC 2021 JD, to 2613, GJ Para 39. Recording statements must be recorded like civil court evidence, S65(3). The validity of the record depends on whether it fulfills statutory objectives. Pickford v. Engelbrecht No 2020 Sorch 163 Para 14. Disclosure requirement. The insolvent must declare full disclosure of all affairs, S65(4). Fairness and justice. The presiding officer must conduct the interrogation fairly. Advanced Mining Hydraulics v. Botes No 2000, 1, SA 815, T. 824. Court intervention. The court can stop an interrogation if it is abusive, vexatious, or oppressive. Lane v. Magistrate, Winberg 1997, 2, SA 869, C. 874. Relevance and exclusion of questions. The presiding officer must disallow irrelevant or unnecessarily prolonged questions. S65(1), Agirakis v. Gunn, Supra, 605. Credibility questions, allowed if relevant to the insolvent's affairs. Pretorius v. Murray 1981, 1, SA 1051, A. 1063-4. Constitutional rights. Questions infringing constitutional rights are unlawful. Harkson v. Lane No 1998, 1, SA 300, CC 332. Public/private proceedings. Inquiry is not necessarily public unless required. Revie di Meester 1997, 1, SA 815, T. 825. Legal representation. A person may be assisted by an advocate, attorney, or agent and must be informed of this right. S65(6), Advanced Mining Hydraulics v. Botes No Supra. Access to information. No right to prior access to information before the inquiry. Pizzolady v. Van Rensburg 2002, 2, SA 160, SC 162. Pending civil trials, a witness in a pending trial can still be interrogated. Pretorius v. Murray, Supra, 1064. Procedural role. The inquiry does not decide rights, it gathers information. Pickford v. Engelbrecht No, Supra, Parrot 26. _. 13.1.6 Privilege. General principle. Privilege applies to evidence and documents, but some exceptions exist. S65-2. Self-incrimination. Witnesses cannot refuse to answer on self-incrimination grounds, or due to pending criminal charges. S65-2 Proviso. Banker's obligations. A banker must produce checks and records related to the insolvent or spouse from the past year. S65-2. Use of evidence. Evidence from an interrogation is admissible in civil and perjury-related criminal proceedings. S65-5. Limitations on use of incriminating evidence. Incriminating/protected evidence must be heard in camera, and its publication is prohibited. S65-2AA. Incriminating evidence cannot be used in general criminal proceedings, except for perjury-related offenses. S65-2AB. Hodgson v. Magistrate, Winberg 1997, 2, all SA 205, c. 211-12. Rationale. Ensures full disclosure of financial misconduct. Prevents examinees from avoiding questioning due to potential self-incrimination. Duplessis No v. Oosthuizen 1995, 3, SA 604, 0, 613. Wessels No v. Van Tonder 1997, 1, SA 616, 0, 621. Companies Act Parallel. Companies Act 61 of 1973, S 415-5, allows use of interrogation evidence in all criminal proceedings. Duplessis No v. Oosthuizen, Supra, 609. Pablo v. Getz No 1997, 4, SA 1095, cc, held S 415-5 unconstitutional for allowing such broad use. Conclusion. S65-5 is constitutionally sound due to S65-2AB, limiting evidence use in criminal proceedings. Protection against prejudice. Equisec v. Rodriguez 1999, 3 SA 113, W. Rejected debtors' attempt to stay sequestration due to pending criminal charges, as S65-2A sufficiently protects against prejudice. Weight of interrogation evidence. Evidence is admissible but not automatically proof of facts. Court decides credibility. Duplessis No v. Oosthuizen 1999, 2, SA 191, 0206. _. 13.1.7 Failure to attend or submit to interrogation. Warrant for arrest. If an insolvent or summoned person fails to attend a creditor's meeting, the presiding officer may issue a warrant for their arrest. S66-1. Committal to prison. If no reasonable excuse is given, the presiding officer may commit the person to prison for an unspecified period. S66-2. The prison officer must detain and produce the person when required. S66-2. Failure to produce documents or answer. A person who appears but refuses to produce documents, take the oath, or answer satisfactorily may be imprisoned until compliance. S66-3. If an answer is evasive, clearly untrue, or incomplete, it can be treated as a refusal. Nievold v. Fort No 1987, 4, SA 101, c. 109. Repeated non-compliance. If the person fails to fulfill an undertaking after release, they may be re-imprisoned as necessary. S66-4. Appeal to High Court. Detainees can apply to the High Court for release if wrongfully detained. S66-5. Presiding officer's immunity. Enjoys the same immunity as judicial officers for acts performed in their capacity. S66-6. Constitutional concerns. DeLange v. Smuts No 1998, 3 SA 785, cc, held as 66-3 unconstitutional, to the extent that non-judicial presiding officers can imprison individuals. Effect: only judges or magistrates can order committal under S66-2 and 3. Ackerman J's suggestion. specialized insolvency courts, or integrating officers into the judiciary, could resolve the constitutional issue. _ 13.1.8 Interrogation revealing possible offense. Referral to DPP. If interrogation suggests reasonable grounds for suspecting an offense, the master must refer the statement and documents to the Director of Public Prosecutions, DPP, for consideration of criminal prosecution, S67-1. Next. Page 13.2 Interrogation by the Master. General provisions. The master can initiate an inquiry if they deem it necessary to obtain information regarding the insolvent estate, the administration of the estate, claims or demands against the estate, S152-2, Berdanovi Besta No 2022 JDR 0820, CC, Par 11, the master may summon any relevant party to appear before them, or a designated official, S152-2. This power is exercisable at any time after sequestration, including provisional sequestration, and before rehabilitation, S152-2, Appleson v. The Master and Others 1951, 3, SA 141, t. No need to prove that interrogation under S64 or S65 is impossible or impractical, Pauls v. The Master and Others 1998, 4, SA 212, c. 224-5. The master can administer an oath, S152-4, allow interrogation by the trustee or their agent, S152-4, recall the person for further interrogation or document submission, S152-3, right to privacy, S14 of the Constitution, is subordinate to the need for information, Gumede and Others v. Sabal No, and Others 2006, 3, SA 498, SCA 504-6. Applicable provisions. Privilege and self-incrimination. The same rules as interrogations by the trustee apply. Wessels no v. van Tonder N. Ander 1997, 1, SA 616, 620. Failure to attend interrogation and witness fees. A witness is not obliged to attend unless offered prescribed fees. Swat N. Ander v. Kronia N. Ander NNO 1991, 4, SA 296, t. Laskerides and Another v. German Tire Center, Proprietary, Limited in liquidation, and Others NNO 2010, 1, SA 390, W. 399. Distinction between S152 inquiry and S65 interrogation. Stadler N. Ander v. Wessels no N. Ander 2000, 4, SA 544, 550-4 outlines the differences. Legal principles on the nature and scope of the inquiry. Purely investigative. The inquiry does not determine rights or make findings affecting any party. Van de Westhuizen v. Ruet, and Others 1986, 1, SA 693, N. 698, Podlers v. Cohen and Bryden NNO, and Others 1994, 4, SA 662, p. 675, Ruvida Meester NN Ander 1997, 1, SA 815, t. 824, Netbank Limited v. Master of the High Court 2009, 3, SA 403, W. 414. No application of the Audi Alterum Partem rule. The master is not required to hear the other party before deciding to hold an inquiry. The examinee cannot demand presence at examinations or cross-examine witnesses. Podlers v. Cohen and Bryden NNO and Others, Supra, 675, Ruvi die Meester NN Ander Supra. Procedural fairness. The presiding officer must ensure fairness, but does not need to disclose the basis for holding the inquiry. Strauss and Others v. The Master and Others NNO 2001, 1, SA 649, t. 662-3. The examinee has no constitutional right to the information that led to the inquiry. Strauss and others v. The Master and others NNO, Supra, 665-6. Courts can intervene in case of abuse. Courts may restrain misuse of the inquiry if it provides an improper forensic advantage. Urquhart v. The Master of the High Court 2019 JDR 2000, FB, Para 11. Examples of abuse. Summoning a witness to benefit a third party. Using the inquiry as a pretrial discovery tool when such discovery was refused. Holding the inquiry solely to extract admissions for negligence claims. Scheduling an inquiry to obtain litigation ammunition before a trial. Flexibility of inquiry procedure. No formal record-keeping requirement. Stadler N. Ander v. Wessels No N. Ander, Supra, 554. Legal representation. No automatic right to representation, but it is often allowed. Appleson v. The Master and others, Supra, Van de Vesthuizen v. Ruert and others, Supra, 699. Representation is especially desirable when interrogation is linked to hostile litigation. Hosking and another v. Van der Merwe, and another NNO 1992, 1, SA 920 W. Confidentiality concern. Preventing all witnesses from having the same legal representative maintain secrecy. Myberg v. The Master of the High Court Bloemfontein Free State Division, Bloemfontein No 2019 JDR 1698, FB, Para 16. Limited judicial review. Court review under S-151 is restricted to cases where the master acted in bad faith, mala fide, had ulterior motives or failed to apply their mind. Strauss and others v. The Master and others NNO, Supra, 656-7. Courts may intervene in the inquiry only if the inquiry is oppressive, vexatious, or causes undue hardship to the examinee. Exceptional circumstances justify interference. Strauss and others v. The Master and others NNO, Supra, 662. Next page. Chapter 13 Interrogation by the Master. 13.2 Interrogation by the Master. The Master may initiate an inquiry if the insolvent, trustee, or any other person can provide relevant information about the insolvent, his estate, the administration of his estate, any claim or demand made against the estate. S-152-2. The Master may summon a party to appear before him, or a magistrate or public service officer, to provide information. S-152-2. The Master's power to summon applies at any time after sequestration, including provisional sequestration. Appleson v. The Master and others 1951, 3, SA 141, t. Before the insolvent's rehabilitation. S-152-2. No need to show impossibility of interrogation under S-64, or S-65, Calls v. The Master and others 1998, 4, SA 212, c. 224-5. The Master can administer the oath to the summoned party, interrogate the party along with the trustee or trustee's agent, S-152-4, require further appearances and submission of books/documents, S-152-3, constitutional considerations. The right to privacy, S-14 of the Constitution, is outweighed by the relevance of documents to the insolvent's affairs. Boumede and others v. Sabal No and others 2006, 3, SA 498, SCA 504-6. Application of trustee interrogation provisions to S-152 inquiries. Privilege and self-incrimination rules apply. Wessels No v. Van Tonder N. Ander 1997, 1, SA 616, 620. Rules on failure to attend, presiding officer immunity, and witness fees apply. S-152-5, 7. Witness attendance requires prior payment of fees. Swat N. Ander v. Cronia N. Ander NNO 1991, 4, SA 296, t. Laskerides and another v. German Tire Center, Proprietary, Limited in liquidation, and others NNO 2010, 1, SA 390, W, 399. Differences between S152 inquiry and S65 interrogation, Stadler N. Ander v. Wessels No. N. Ander 2000, 4, SA 544, 550-4. Legal nature of the inquiry. Investigative purpose only. The presiding officer does not make findings affecting rights. Van der Westhuizen v. Ruert and others 1986, 1, SA 693, N. 698, Podlers v. Cohen and Bryden NNO and others 1994, 4, SA 662, T. 675. No application of the audi alteram partem rule. The master need not hear the party before deciding on the inquiry. Podlers v. Cohen and Bryden NNO and others, Supra, 675. The insolvent has no right to be present or cross-examine witnesses. Ruvi die Meester NN Ander 1997, 1, SA 815, T. 824. Procedural fairness requirement. The presiding officer must ensure fairness, but need not disclose reasons or information leading to the inquiry. Strauss and others v. The Master and others NNO 2001, 1, SA 649, T. 662-3. No constitutional right to access inquiry information. S32 of the Constitution read with SCH 6, Item 23, Strauss and others v. The Master, and others NNO Supra, 665-6. Judicial control over abusive inquiries. Courts must prevent inquiries used for improper forensic advantage. Urquhart v. The Master of the High Court 2019 JDR 2000, FB, Para 11. Examples of abuse. Summoning a witness to aid a third party in litigation. Using an inquiry for pretrial discovery after a discovery order was refused. Extracting admissions for a negligence claim. Conducting an inquiry just before trial for strategic purposes. Procedural flexibility. No mandated procedure or requirement for record-keeping. Stadler N. Ander v. Wessels No. N. Ander, Supra, 554. Legal representation. No automatic right for representation except for the trustee. Appleson v. The Master and others, Supra. Desirable to allow legal advisors, particularly in hostile litigation. Van der Westhuizen v. Ruert and others, Supra, 699. Hosking and another v. Van der Merwe, and another NNO 1992, 1, SA 920 W. Insolvency inquiries are confidential. Multiple witnesses should not share legal representation. Myberg v. The Master of the High Court Bloemfontein Free State Division. Bloemfontein No. 2019 JDR 1698, FB, Para 16. Limited court review under S151. Court interference allowed only if the master acted in bad faith, with ulterior motives, or failed to apply his mind. Strauss and others v. The Master and others NNO, Supra, 656-7. Court may intervene if inquiry is oppressive, vexatious, or causes undue hardship. Eden 662. Chapter 14. Duties of the insolvent. 14.1 Delivery of records and statement of affairs. Upon final sequestration order. Immediate delivery of all financial records to the sheriff, S16-2A. Within 7 days, submit a statement of affairs to the master in duplicate, verified by affidavit, S16-2B. If assistance is required, the master may approve a reasonable fee from sequestration costs, S16-5. 14.2 Delivery of assets. Within 14 days of trustee appointment, the insolvent must hand over any estate property in his possession, S136B, I. Failure to comply is a criminal offense, IBID. 14.3 Providing assistance. Before the second creditors' meeting, the insolvent must assist the trustee in collecting and securing estate assets, S2312. Entitled to support allowance from the estate for assistance, IBID. 14.4 Providing information. Criminally liable for failing to provide information to the trustee/master. Within 14 days of trustee appointment, disclose estate property not in his possession or listed in the Statement of Affairs, S136b, 2, 4. Upon trustee's request, provide full and truthful details of any property lost, transferred, or disposed of, S136c. Must account for missing property at a creditor's meeting, S138c. Must report suspected false claims against the estate within 7 days, S136a. Must provide a detailed explanation of his insolvency and excess liabilities upon request, S138b. 14.5 Informing trustee of addresses. Must keep the trustee informed of residential and postal addresses, S2313. Notices under the Act can be sent by registered mail to these addresses, S2314. 14.6 Record of assets and disbursements. Must maintain a record of all assets received and disbursements made in his profession or employment, S23.4. Trustee may inspect records anytime, IBID. If required, must submit a monthly statement, verified by affidavit, of assets received and disbursements made, IBID. The trustee may request supporting vouchers for any item, IBID. Deficiency in S23.4. No obligation to update the trustee on financial status post-asset distribution, ex parte Jacobs 1977, 4, SA 155, North Carolina, 156-7. 14.7 Attending meetings and giving evidence. Must attend creditors' meetings and submit to interrogation, C13, Lot 1-2. Must appear and answer questions in court proceedings involving the trustee if summoned, S140. Failure to comply is a criminal offense, IBID.